It's Entertainment Law Update, episode number 181 for June 25th of 2025. Hi, everybody. Welcome to Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And it is great to be with you again here. This is our podcast by entertainment lawyers about entertainment law, where each month we round up notable cases, news, and information, try to keep you informed and hopefully a little entertained. And we do, welcome your feedback and suggestions and input. So please do visit entertainmentlawupdate.com. You can use the voice widget we have there over on the side of the screen and send us email. Is another way at entertainmentlawupdate@gmail.com. You can find us on social media and so on. But Tamara, what's new with you and your end of the world?
Oh, just feel like we're going a lot of different directions. Busy, jumping straight into summer. Going to be traveling some next week and going to Tennessee, see family. So that'll be nice over the kind of that week leading up to July 4th. So happy about that. I'm guessing you're full on with kiddo activities and summer on your end as well.
Yeah, well, my oldest is in Europe for a few days with some classmates at school, and it's a whirlwind tour, but boy, do I envy him. My daughter just got back from a short trip, and she's on the swim team, so she's practicing swim practice every day this summer. And
at what time? What time do you have to take them for swim practice?
Well, her practice at 4 in the afternoon, so it's not too bad.
Oh, really? Yeah. Here it's like 5 a.m. It's like...
Well,
Brock was like a good swimmer, and I'm like, it's not happening, kiddo.
There's something to be said for beating the morning heat and stuff like that, but 5 a.m. is crazy.
Yeah, 5, 6 a.m. I'm like, neither one of us is going to make that happen.
Yeah. And then the youngest is I think he's in Minecraft mode all summer long.
Yeah, mine still is too. They don't seem to grow out of that.
If it's harmless. At least they're not out smoking and drinking and doing things they shouldn't be. So
I don't know, because mine's in Europe all the time.
Well, and he's an adult.
And a little bit older, and he's an adult. So that's true. He is an adult.
Well, let us be adults and jump into our our rundown for this month's episode. First off, there's some news coming out of the trademark office that practitioners should be aware of. This came to my attention in the trademark listserv, which for those who aren't familiar with it, if you are doing trademark work at all, this listserv is a great resource where lots of experienced lawyers are sharing insights and ideas and thoughts, and this came up there. On May 15th, the Patent and Trademark Office introduced new security measures for certain of the forms in the TEAS, the Trademark Electronic Application System forms, really in their efforts to try to reduce the number of fraudulent filings. And the system now will determine whether you can file these forms without additional authorization based on the information on file with your USPTO.gov account. And some users will need additional authorization to submit forms, especially forms like change of attorney. They call it change of representative, CAR form, and things like that. And the issue with it is that what they're doing is they're saying if you're going to change attorneys, if you're going to substitute in as counsel, you may need to get approval from the prior attorney or whoever did the filing. Now, that's, I can understand how that makes some sense, but the folks in the listserv are a little bit concerned that this will raise problems. Because you log in, you want to do your thing, and then you have to wait until someone else clicks through, and they're in no big hurry because they're no longer doing the work on the file.
That's right.
And if you're up against a tight deadline, like for example, an abandonment of a trademark application or something like that, you could end up missing the deadline because you're waiting for this authorization.
Yeah.
Plus, if the attorney and the client are on the outs, or the attorney's no longer available, died, disabled, on vacation, whatever, you're going to be sort of stuck. And it doesn't seem to provide an option for the applicant themselves, the owner of the mark, to do the authorization. And so there's questions about, well, what do you do?
Okay. So I've had real world experience in the last week.
Oh.
Because, and this is interesting, I wonder if I must be on the hot list. And I'm wondering why. And now that we're talking through it and I'm hearing you like read it out loud or speak it out loud, because there have been hundreds of applications in which my attorney of correspondence and representation has changed in the last few months.
Oh, of course.
Why? Because I changed law firms. So every one of those that I'm continuing to represent, I have to go in and file. So hundreds.
Yeah.
So that one may have put me onto a list somewhere in the system. So I need to follow up on that and see if that's what happened to me. But only last week did we start receiving to my prior email address, which I still have immediate access to. Hey, somebody just submitted to change the attorney of record, and then we have to verify. I'm like, what the heck? What happened here? So then I go read and realize I had missed this USPTO announcement of this change. Okay, that's easy. I have access to my prior email address. I can click the box and move on down the road. What's not easy is I have a new client who was not a previous client with trademark registrations, with a lawyer who has now closed their law firm. And to my knowledge, I don't know if they have access to an email address connected to that previous filing. Another with one of the big entities that files lots of trademarks for people.
Yeah. You mean the kind that has words like Zoom and Rapid and Fast and Rocket and things? Okay.
Yes. Do you think they're going to reply to approve it? So 48 hours is come and gone. You're supposed, the listed attorney of record is supposed to respond within 48 hours. Now, ways that this could be overcome. So let's say you do need to make a filing. So in your example of an abandonment or a response to office action or a Section 8 and 15, you can file those, and that should trigger an update of the attorney of record. I haven't done that yet. In my particular situation, no immediate filing is due. So I can't file it on behalf of the client to get it changed. And it also goes against the rules of the USPTO that says once
the application is approved, you're no longer
approved or denied, you're no longer the attorney of record. So what am I supposed to do? Well, right now, as we speak, on the 25th of June, there is a seminar going on by the USPTO where I believe they are talking about this. So as I mentioned prior to our call, my listserv connection is being a little wonky. So if you see some good information in that, forward it on to me. So anyway, just an update. If you are on the receiving end, or if perhaps you're no longer representing clients, you may still need to be having access to an email. So don't be surprised if you get it. Go double check it.
Yeah.
It's frustrating.
It seems to me that this is sort of a pattern with the USPTO in particular. Not all the government agencies, but the Patent and Trademark Office seems to shoot first, gonna ask questions later with changes in their systems and security, and oftentimes they're not real open to asking questions afterwards. And so this is another example of them sort of breaking things by accident or unintended consequences. Certainly it's a problem that there are outfits out there that are substituting in when they're not supposed to and things like that. But this raises other
that happened
issues.
to a client.
Sure, yeah.
But they didn't even do it by changing the representation form. They were just a bad actor who paid the money and filed the Section 8 and 15 or the 8. I mean, it was. I've known 2 times that's happened. Once for me and once for a colleague. So there are ways around that.
In your particular situation, I'm surprised that just changing the account, your address and contact information in your USPTO account didn't sort of cascade through and update everybody who has you as listed as attorney of record.
It does not. It has to be an affirmative action to change it.
That's interesting.
Which I'm actually okay with that, because in some situations that it may not be a continued representation.
Sure.
So,
no, there should be some friction to making these kinds of changes. But on the other hand, you got to make it actually possible in those situations where the attorney, the prior attorney is no longer available or unwilling or whatever. And they don't seem to have anticipated that problem. So we'll see.
So like I said, I'm not going to, obviously we're doing this recording at the same time that they're doing this live webinar. So I'm hopeful we'll see some updates maybe in the group
and we
later
will report
today.
Back.
And we will report back, and I'll give you guys an update of what I had to do on my end so that I can represent my client at the USPTO. So we've also got an update from the U.S. Copyright Office. I don't know if folks are in there often searching records at copyright.gov, but there's been the traditional system we've used for decades. And then for the last several years, they've been running a pilot program, which is the Copyright Public Records System. And if you ever searched through that system, a little message warning Will Robinson popped up that said, "This is not official. You can't trust what's in here." Well, that has changed. Now the Copyright Public Record System has replaced what we previously used, which was the online public catalog. It is, I think, easier and provides us more information. It provides copyright registration and recordation data, advanced search capabilities that are just easier to use than the prior advanced search capabilities, filters. It does have a better public interface. There is another section of this, that's another component that's going to be made public, the Office's Enterprise Copyright System. I'm not familiar with that. And again, since 2020, this pilot program has been in play. It does go back. Obviously, you can see records back to 1978. There are other systems available where you can look and search the actual card catalog filings. You have to be a person of a certain age to remember that they used to be on little index cards, and you can go see all those little index cards. So anyway, I think that has been a good change.
Indeed.
A good technology change. It makes it way easier to search, a whole lot easier to print, export the information. So,
and honestly, just a much nicer looking user interface. It feels like it's finally catching up with modern design sensibility.
It does. I mean, there may still be situations where you need to hire a search either through the registered copyright office or through a third party, but for most non-super advanced searches, this is going to really improve the system. And just the fact that they're so much easier to export is a big thing. So,
well, good. I tinkered with it the other day, and it was, it certainly found all the applications with the word Firemark in them. That was a search I did, and I should say all the registrations and records, and I was surprised to see how many I've done over the years. So.
Right, and you can. What's nice on this one, you can limit it by the type of registration that was issued. If it was sound recording or text or PA or performing arts. Again, some of us know what all those initials stand for, and others, newer licensed attorneys and practitioners, may not. So, because they never filed a paper form.
Brings back memories. Well, speaking of memories, most of us remember the spate of car chase films that have happened over the years, and we now have a ruling from the Ninth Circuit in the case of Carroll Shelby Licensing Inc. versus Halicki. This involves the iconic Mustang named Eleanor, featured in 4 of those car chase films, and finding that it does not qualify for copyright protection as a character. So Denise Halicki is the widow of the filmmaker Toby Halicki, H.B. Toby Halicki, who spent over a decade asserting exclusive rights over these customized Mustang designs that resemble those used in the Gone in 60 Seconds franchise. Carroll Shelby Licensing and Carroll Hall Shelby Trust, the successor entities to the race car designer Carroll Shelby, they licensed the GT 500 CR replica Mustang through a company called Classic Recreations. Denise Halicki claims copyright and contract rights in the Eleanor Mustang appearing in those 4 films. Eleanor's it's the name given to the stylized Mustang in films from going back to 1974, 82, 83, and 2000. And Classic Recreations and its principals are the builders of these Shelby licensed GT500 CRs. So there had been this lawsuit over that replica prior and settled back in 2009, and that barred Shelby from copying only the raised hump on the hood and inset lights of the Eleanor design. Well, that dispute bubbled back up and arose in 2017 after Shelby licensing and the trust authorized Classic Recreations to manufacture the GT500 CR replicas, which are modern recreations of the vintage GT500. Halicki claimed that these replicas infringed her purported copyright in the Eleanor design, and she further alleged that the new models violated that 2009 settlement agreement. Well, Shelby preemptively sued, looking for declaratory relief, asking the court to affirm that its 500CR design did not infringe any of Halicki's rights. She counterclaimed, citing copyright infringement, breach of contract, and the Central District granted summary judgment for Shelby on the copyright issue, finding that Eleanor was not copyrightable. After a bench trial on the contract and declaratory relief claims, the court ruled that Shelby had not breached the 2009 settlement, but declined to issue a declaratory judgment. That's interesting. Shelby appealed the denial, and here we are. So on May 27th, the Ninth Circuit affirmed the lower court's findings on both copyright and contract, applying the 3-part test from DC Comics versus Toll. That's the Batmobile case.
Yeah.
The court held that Eleanor did not qualify as a protectable character under copyright law, saying that on the conceptual qualities, Eleanor lacked the human-like traits, autonomy, or consistent persona. It was a car used in stunts, not a character with any kind of sentience or personality of its own. On the consistent identifiable traits, the Mustang's look, behavior, and role varied across the 4 films, and that sort of undermined any claim of distinctiveness there. And unlike the Batmobile and Toll, Eleanor was merely a named prop without sufficient unique features to justify copyright protection. And the court emphasized that mere fame or stylization isn't enough to transform a car into a protectable fictional character. Also upheld the district court's conclusion that Shelby hadn't violated the 2009 agreement, the settlement. The contract specifically prohibited only the copying of this distinctive hood hump and the inset lights that were features that were absent from the GT500 CR replica. So they rejected the argument that from Halicki that the other provisions implicitly extended broader protection to the Eleanor character, relying on California contract interpretation principles, and the panel concluded that interpreting the agreement to cover additional design elements would render key clauses superfluous. So the appellate court did reverse the district court's denial of declaratory relief and ruled that Shelby was entitled to the declaration that its GT500CR did not infringe Halicki's rights, noting that ongoing legal threats and public confusion did justify a formal clarification. So now the case goes back to the district court, basically just to issue the appropriate declaratory relief. So,
yeah. And I mean, and different from the Batmobile, there were no, this is what the court kind of, in my mind, hung their hat on. There were no human traits to Eleanor. Not that Eleanor needed to be speaking like one of the cars in the movie Cars.
Yeah.
But there was, it just wasn't this, it was more of a prop than a character is the language the court used. And
merely giving it a name and having a distinctive paint scheme or design doesn't necessarily make it a character, a person in the.
That's right. Yeah. And I suspect that hung on it being just a utilitarian.
Yeah.
I mean, there's no question to say that if there was some elaborate original paint scheme or design,
Yeah, that could
that
be.
portion could be protected, but not the utilitarian function of a car.
Yeah, and I think
that's the difference with Batmobile.
Yeah, that's probably where the hood hump settlement thing came in, is that was something that was original, created for the character, for this car, for the movie, that is different and new, and so that part of it would be, yeah, but that wasn't included in this version of the car. So yeah. So yeah, I mean, I always thought that Batmobile case was a little tricky and sort of very narrow in articulating when is an inanimate object a character in a film. So I think it's limited pretty much to those facts or very similar. So
yes, and I think we look at it, well, again, the example of the cars in the movie Cars.
Yeah.
That is a animated cartoon, or animation.
Well, and those characters are really given personalities and features.
They have human traits and qualities, and
and the storytelling revolves around them rather than features them, and as a prop, as you said here. So
you can say I must not be a big fan of the series because I had no idea there were ones prior to 2000. But now I'm curious to go back and watch some of the older ones just to see.
Yeah, I'm sure the 1974 is different. Something to see.
Oh, I'm sure. Again, I think we've discussed my love of like all things Rockford Files, so that would kind of fit right in with that time period. So totally. I probably would love it.
Mm-hmm. Oh man! All right. Well, this next story involves baseball. The Cubs, the Chicago Cubs, have sued one of their neighbors at the stadium in Chicago. For nearly 2 decades, the team behind, the storied franchise, the Chicago Cubs Baseball Club LLC. I didn't know it was called Club LLC anyway. And they're the operator of Wrigley Field. They used to allow rooftop businesses nearby Wrigley Field to sell tickets to game day views in exchange for royalties and a promise to follow certain rules and restrictions, including how the Cubs trademarks could be used. And there was a settlement agreement back in 2004 that expired in December of 2023. Now, rather than renew that agreement, a company called Rooftop by the Firehouse, Inc., which operated the Wrigley View Rooftop, which is a venue selling tickets to watch Cubs game from this building adjacent to Wrigley Field, they decided to continue selling those rooftop tickets and advertising itself as the, quote, official partner of the Chicago Cubs, despite no longer having the license to do so. So according to the Cubs, this amounted to unauthorized use of their trademarks and an attempt to mislead the public into believing that there was still an official relationship. So the Cubs sent cease and desist letters, and the conduct continued. So the Cubs filed suit in federal court. This is the Northern District of Illinois, asserting a series of claims grounded in both federal and state law. First off, federal trademark infringement, unauthorized use of the registered marks such as Chicago Cubs and Wrigley Field. There's a false designation of origin, an unfair competition claim, a 43A claim, misleading advertising that suggests an official affiliation. There's false advertising, the promotion of rooftop tickets as being an official Cubs experience, deceives consumers. There's also a State Deceptive Trade Practices Act claim, a common law unfair competition and misappropriation claim, and an unjust enrichment claim. Now, rather than directly addressing the claims of infringements, the defendants just filed a motion to dismiss under 12b-3, arguing that the matter should be resolved in arbitration, not because the settlement agreement contained an arbitration clause. Not in court, because the expired settlement agreement had an arbitration clause, which they say still applies to disputes arising from the ongoing operations. So the Cubs are responding that the misconduct occurred after the agreement expired and therefore fell outside the scope of the arbitration clause. So the defendants have now shifted course and asked the court to treat their motion as one for forum nonconvenience, essentially arguing the wrong forum was chosen. So the judge, Sharon Johnson Coleman, denied that motion to dismiss and ruled that under Rogers Rousier versus American Queen Steamboat Operating Company, the Rule 12b3 is no longer a valid vehicle for enforcing arbitration clauses. So that's interesting. And the court refused to convert the motion into one based on form and nonconvenience because the argument was only raised in the reply brief for the first time. So clear precedent and timing requirements. The court said the defendants filed a second motion to reconsider or compel arbitration. And again, that was rejected because the misconduct occurred after the agreement expired and the survival clause didn't list the arbitration clause.
Interesting.
Yeah, and no clear.
That's a practice pointer, right? Isn't it? If you, one way or the other, if you want to be in arbitration after the fact.
I can just imagine getting into negotiation battles over whether or not it should be included in the survival clause. But anyway, then just
I
if you're agreeing to arbitration, why would you object?
There are times and places where I think arbitration is a good thing. Yeah. There are also many times and places where that's not going to be my first choice recommendation.
Yeah.
So, but I could see why. I actually could see why the Cubs would want that, because they probably wouldn't want it playing out in the public light. But in this situation, it's probably in the Cubs. I don't know. It's in the Cubs' favor for it probably to be playing out.
I think they have calculated and thought that for whatever reason, using the courts may be the more effective at exacting, if not an outcome through the courts, but a settlement.
Through a settlement, it would seem much more encouraging of a settlement, especially. So I would have to assume that for the 2024 season, this is when all these activities occurred. And what I don't know is if licensing agreements were reached with other venues, because it's my recollection that there are other locations that look into the field.
Yeah. It does raise sort of interesting questions about how much can you protect when the show, the game, is occurring in a place that is viewable from nearby. Certainly on the trademark and unfair competition, you shouldn't be advertising that you're affiliated or official or something or in partnership with the Cubs. But if you say, hey, our place is next to Wrigley Field, come, have dinner with us and watch the game.
I think you can. I think that's nominative fair use. I think it's the issue that they were saying that they were somehow official.
Right. So
is the real issue.
Yeah. I mean, one of the allegations in the case, though, is that the Cubs are alleged that the Rooftop is effectively selling access to their live performances and leveraging the team's copyrighted and trademark content. Now, the copyright issue seems like it doesn't get very far. I mean, it's a lot. It's something happening in real time, and it's viewable from outside. You can't stop.
Yeah, it's not fixed. It's not a copyright protection until it's fixed. So if I'm watching it, there's no copyright.
It's interesting. In talking about this the other night with the team as we were prepping for the show, Charles was able to recall in his youth going and sitting in the car just outside the drive-in movie theater and watching the movie, what he described as grown-up movies, from outside the fence of the drive-in. And, what could they do to stop that? It's a similar scenario. But here the difference is nobody was saying that their parking lot next to the drive-in was officially sanctioned or a partnership with the drive-in theater. So I think that's where the stronger claims in this case lie, for sure.
Yeah, I think so too. But there was no ruling on the substantive merits of the intellectual property claims. I think it was kicked back down, though, for a ruling on that. But arbitration is not going to hold up. So that's not going to be the next step for this.
Okay. Well, we'll hear more, I'm sure.
Yeah.
Remember we talked a few months ago about the social media influencer who was suing another social influencer over the vibe of the posts that they were making?
Yes. Yeah. That was episode 175.
Is it that long ago?
Maybe I had to look it up because it was so beige, I just didn't remember. But
So apparently the vibe is referred to as sad beige, whatever that means. So you want to take this one?
I will. So, there's a little backstory to this that I did have to go back and look at our notes from our previous rundown to take a look at. It was that the plaintiff and the defendant in this case are both social media influencers. The plaintiff, we're going to call them by their first names just to keep this easy. The plaintiff is Sydney and the defendant is Alyssa. And in 2022 and 2023, they actually worked together or met each other in 22, worked together in 23 on a photo shoot, and then things kind of fell apart after that. So in 2024, the plaintiff, Sydney, filed a lawsuit against Alyssa, who is also another social media influencer, in federal court in Western District of Texas. Sydney accused Alyssa of copyright infringement, trade dress misappropriation, and unfair competition for copying her, the plaintiff. She claimed that Alyssa copied her social media post, replicated her brand identity by featuring the same or substantially similar Amazon products that Sydney promoted and also copied her brand image or vibe by mimicking the styling, themes, camera shots, angles, and text captions along with other elements. And Sydney's social posts, the plaintiffs, have a distinct cream and natural beige theme. Okay, copyright infringement claim. Plaintiff Sydney had registered several of her posted videos and pictures with the Copyright Office. Good for Sydney. That's a smart thing to do for all social influencers. And some of defendant Alyssa's posts were removed from TikTok, Instagram, and Amazon pursuant to copyright infringement reports that I'm assuming Sydney filed. Sydney claimed that Alyssa's infringed her copyright materials by copying elements of the original works and then reproducing those elements in her copyrighted works and posting similar influencer posts, which featured identical products. Saying that the platforms with identical styling, tone, camera angle, and or text captions. So I'm going to just jump in right here. This feels a whole lot like what we talked about last episode or the month before related to Little Nas X.
Oh, yeah.
Yeah. So, and that just because we have some of the same elements or posting within a social media post does not mean copyright infringement. And then there was also this claim under the DMCA, interesting, regarding removal of copyright management information. Well, if the defendant created her whole brand new videos, I don't see how the DMCA copyright management information applies, but good try on trying to get that one in. I think it's an underused, and we should utilize that cause of action more often in these. I actually do believe that. We need to work on using that one more.
The copyright management claim?
Yeah, I think it should be used. I don't know that this is a winning argument, but I think we need to remember to use it. Plaintiff Sydney claimed she has a distinctive trade dress. So maybe trade dress is a little more actionable. I don't know, but a monochrome cream, gray, natural beige colors coupled with modern, minimal, sophisticated styling of Amazon products on their social media platforms. I mean, maybe there is a distinctive trade dress tied into that.
It seems to me that with something like beige color scheme and sort of that washed out cream gray natural beige color scheme, I don't know that you can call that distinct. It'd have to be pretty, well, I don't know. I guess distinctiveness is something that can be earned, so maybe, but it strikes me as
I don't
stretch.
Well, it does have to be earned.
Yeah.
Has she been doing this for 5 years or more and we identify only her with that? I don't know. Anyway, again, to argue that there's a copying of the trade dress, that there's a likelihood of consumer confusion, that online users will be confused about the source of the videos. This is also increased because of the algorithm employed by social media platforms who recognize colors, shapes, and stylings in how they suggest videos to users. So we're not going to get an answer, though, Gordon. Sorry. Because they settled. They filed a stipulation to dismiss the case with prejudice because they settled the dispute, and it concluded with the settlement agreement. And I haven't gone online to see if the defendant has changed her color scheme or not.
Nor have I.
But I mean, I think it's an interesting argument for those that are in that space, maybe to look through, see how you can differentiate yourself one from the other. And, you know, we don't need to be copying each other, but it's settled. And so now we don't know if beige is a trade dress or not.
Well, to all those influencers out there, be original, be different, distinguish yourself. Don't try to mimic. I guess that's...
Yeah, and I don't think Amazon cares if two people or more are trying to sell their product.
No, I mean, they have their affiliate, what do they call it, Amazon Associates program open to everybody. And if a product is listed in the Amazon catalog, you know, you can market and promote it. And I think what's interesting is the choice of which products to sell and market that Sydney and Alyssa were kind of in the subtext is they're fighting over the decisions about which products to market also.
That's right. And it may be
that ownership, but
right. And that influencer is getting a lot of views when they market XYZ products. So I think I will market that as well.
Yeah. Yeah.
And it may be going less to the causes of action and more to reduction of their associate referrals.
Well, I mean, ultimately it comes down to if what's her name, Alyssa's posts were generating enough traffic that it was drawing off customers that would have otherwise clicked through on Sydney's, then I can see why Sydney would be unhappy about that. So, you know, those commissions add up.
Yep.
Well, our next story is a tricky one to cover, and it's a deep river of information. We're only going to barely touch the surface here, I think.
We are not going downstream the whole path in this river. It's a lot.
It caught my attention because I was talking with a friend and colleague who was dealing with a similar, a related issue around government speech and this doctrine that governments do have a right to engage in speech, even when that sometimes affects this, the rights of the public to have access to information and so on. So this is a case out of your backyard, the Fifth Circuit Court of Appeals, ruling that public libraries act as a conduit of government speech, and the First Amendment doesn't guarantee all people the right to receive all information. And it overturns a decades-old precedent and tees up the case to move to the Supreme Court. So in 2021, this group of, the case is called Little versus, is it Llano County? Is that how you say it? Double L-A-N-O?
Llano, but it's Llano.
Llano County, okay.
In Texas, we've lost the whole.
we don't pronounce the Spanish double L-A.
We don't, that's right. It's also Amarillo, so.
Oh, yeah. Well,
I did confirm that because I've always heard it as Llano, even though I'm thinking that's not right.
Right.
But it's Llano County.
Okay. So 2021, a group of residents of Llano County petitioned the library to remove 17 books that they deemed obscene. This ranged from children's books to award-winning nonfiction, including books like They Called Themselves the KKK, The Birth of an American Terrorist Group, by Susan Campbell Bartoletti. It's Perfectly Normal, Changing Bodies, Growing Up, Sex and Sexual Health, by Robbie Harris, and Larry the Farting Leprechaun. That's hilarious. That's a great title. And My Butt is So Noisy. So another group sued the library and the county over the removal of these books on the grounds that the First Amendment right to information, and demanded that the books be returned to the shelves. In March of 2023, the district judge issued a preliminary injunction ordering the return of the 17 books to the library shelves while the lawsuit proceeds. In June of 2024, a three-judge panel of the appeals court were evenly divided. How do you evenly divide a three-judge panel?
I know. It's interesting.
Well, one said the books needed to be returned. The other said, 9 should be returned and others not, and then a third dissented entirely. So the majority supported returning 8 of the books. There's the answer. But a book may not be removed for the sole or substantial reason that the decision maker doesn't wish patrons to be able to access that viewpoint or message, said the primary opinion. So the Fifth Circuit Court of Appeals judges ruled 10-7 in a full court en banc decision to overturn the district court's injunction and return the books to the shelves. The plaintiffs said it's a very disappointing that today the Fifth Circuit has regressed from its longstanding protection of a citizen's right to receive information under the First Amendment, and that it has attempted to create a circuit split by dramatically expanding the scope of the government speech doctrine. So to be clear, the Fifth Circuit overruled the district court's injunction and required that, and that was the injunction requiring the books being returned to the shelf. So don't have to return them to the shelf. So the circuit judge who wrote the opinion, Judge Duncan, wrote that the First Amendment of the U.S. Constitution does not grant us the right to receive information. No affirmative right to receive information. What it is the government can't stop can't stop us from receiving it, and isn't required to make the information available. So, yes, Supreme Court precedent sometimes protects one's right to receive someone else's speech, says the opinion, but plaintiffs would transform that precedent into a brave new right to receive information from the government in the form of taxpayer-funded library books. First Amendment acknowledges no such right. And further, the judge claimed that there is no constitutional rights to specific library books. No one is burning or banning books per se. He wrote that all libraries, in curating which books to have on their shelves, are deeming what literature is worthwhile, and that is therefore a form of speech. So, from the moment they emerged in the mid-19th century, public libraries have shaped their collections to present what they held to be worthwhile literature. What's considered worthwhile, of course, evolves over the years, but what has not changed is the fact, it's true today as in 1850, that libraries curate their collections for expressive purposes, and those collection decisions are therefore government speech. So, interestingly, 7 dissenting judges said the removal of the books was a politically motivated effort to deny public access to disfavored ideas, and that this ruling forsakes core First Amendment principles. So, direct split with the Eighth Circuit, where they recently ruled that public libraries are not entitled to engage in this kind of curation, I guess you could call it. The Eighth Circuit opinion says, contrary to the defendant's contention, the Supreme Court has not extended the government speech doctrine to the placement and removal of books in public libraries. Doubtful that the public would view the placement and removal of books in libraries as the government speaking. So,
yeah, I mean, it's interesting, and I went down the path earlier of actually reading the appellate court decision from last year, in which they did say, so again, this
the evenly divided
evenly divided split of 3. And put the books back in a certain amount of the books. Some of the books they did to make the decision. And as you read through that opinion, as well as this new opinion from the whole circuit, there is this real question in my mind, which pops up into okay, I'll know obscenity when I see it. Obviously, they're not talking specifically about obscenity, but the current standing opinion is everybody agrees you can't be motivated to just remove the book because you dislike the viewpoint in it, or that can't be the reason to remove it. But yet, even if you go through these standards that libraries actually have for deciding what books will be in the library, and it's called weeding it out. I mean, that's the acronym they use for it. You and I could have a different opinion about some of these things. So also other interesting facts that I'm not sure are coming out, and I don't know how this plays out, but these 17 books are no longer on the library shelves. The attorney for the well, for the party who was suing to get the books back in, don't know which, if they were defendant or plaintiff, actually donated the 17 books back to the library. And they are not listed in the card catalog.
Mm-hmm.
But if you know, you can go ask to check them out.
Oh, that's interesting.
And to my understanding, I don't know if this is still the case today, that you can still go ask to check them out. You could a year ago. And they're also available through their digital library loan service.
Oh.
So again, I don't know as of today, post this decision, if that's still the case. So I found that very interesting, that while I could not go in and check the book out physically at the library was not denying complete and total access to the book. So, and it also made me think back to my days of Captain Underpants. I don't know if your kids read
familiar with it.
Yeah. I mean, there were some bodily.
Yeah. Well, it's interesting.
And so, it's like, how do we make this? I mean, is it government speech? Is it not government speech? And so the ruling says that, there's not a violation of First Amendment rights to receive information.
Right. Well, I think that, to go the other way, to restrict the library's ability to curate and require them to have, it opens up the door to say, well, you should have every book ever written, which we're going to talk about in another case in a few minutes. You should have access to everything. But also, I can imagine a scenario where Hustler Magazine is suing libraries for not keeping copies of the magazine on file. And, you have to have some ability to curate, if for no other reason than you only have so much space in the library.
And that's right.
Some things are just not appropriate for public library, I think.
Yeah. And I think we probably are both concerned that other people's standards and requests are then perhaps limiting what's in the library because we don't like it. But you're right. I mean, you don't want, it's one thing to go into the, and they're okay. Those Hustler magazines probably aren't even behind a fold anymore at the convenience store. It's one thing for that, but that is not a go get it behind the counter at the public library.
No, right. And, libraries carry videos, and should they have every X-rated title? Should there, and I mean, I guess there are some titles that are, worth public discourse, even if they are controversial for one way, especially because they're controversial or something. And I guess the real thing is there is a mechanism here that if the community doesn't like what the library board is curating, well, they can eventually vote to reelect or to elect a different library board or different.
And that is what happened in this situation.
Is that right?
The library board members who were saying, no, we need to keep these in the library.
They were ousted.
They were all ousted, along with the head director of library services.
Wow. Okay.
Yeah. And again, I want to also clarify, because we're talking adult content here in our examples, that these were all books
aimed at kids,
that were aimed at children or young adults, young readers. Yeah. And were they age appropriate or not was really the question that was coming in. Yeah. So,
well, this same issue is coming up in the school boards situation, where activist groups of parents are coming, from both sides, frankly, coming in, trying to not dictate, that's not the right word, but trying to influence the board decisions about which books to use for the curriculum, which books to keep in the school library, and those kinds of things. And this government speech, this extends that government speech, not extends it, it affirms that government speech doctrine, and I think sort of empowers the school boards to do curation of the curriculum. Again, there are state level boards and national standards as well that have to be addressed. But, we could see things being removed from school curriculum because a group of parents was unhappy that it was included in the first place, and have pushed the school board to to remove those things. That's always been the case. There's nothing new about that. But this seems to, certainly in the Fifth Circuit now, we have, empowered those activists.
And one of the cases that was cited repeatedly in the opinions related specifically to the difference of a school library versus a public library and what could be in the school library, which is unrequired curriculum versus required curriculum. And, and I have heard conversations or read things where even some of the books that are required, I guess your child can you can have your child exempted from reading a specific book as part of the curriculum if you object. So,
well, these implicate a lot of big issues.
And there was a lot of meat, folks, again, where there was a lot of meat to the current opinion, but I also think you need to go back and read that evenly split 3-judge opinion from last year too.
Yeah, and it does set up a split of authority in between the Eighth and the Fifth Circuit, and our editor on this said that the opinion seems to be daring the plaintiffs to appeal to the Supreme Court by stating that the key case that the plaintiffs held up is the Board of Education Island Trees Union Free School District versus Pico by Pico was not binding and a fractured decision. So they're sort of saying, hey, this one's good for the Supremes. So we'll see what happens. Well, let's move on to the AI stories. We've got a couple of them. First off, the quick take, the couple of the big studios, 2 major studios, Disney and Universal, have struck at the AI companies. There's been a 110-page complaint filed against Midjourney, accusing them of copyright infringement and secondary infringement. This rests heavily on the use or the ability of the Midjourney service to copy and create works featuring protected characters, specifically the Minions from Universal and the Baby Yoda character from Disney Lucasfilm. So the complaint includes screenshots of the content created from prompts as shared by users on Reddit, including Marvel content as well. Side-by-side comparisons between Midjourney content and the characters as they appear in the original media. Some even in the same poses, some side-by-side, stills with movie frames, when asking Midjourney to provide a still image from a point in a film, say Avengers Endgame, for example. The complaint notes that after Midjourney creates an image, it induces members of the public to use the service to make it's some other company makes the images. Anyway, they encourage Midjourney to create the reproductions available through the Explore page. So studios note that Midjourney creates some content blocks already. They prohibit nudity, gore, and some politically tilted content. And the argument follows that Midjourney could try to put in measures to reduce this kind of infringement, but it chooses not to. Midjourney does reference its own right to police the content if they want to, if in their terms of service. And the studios bring up prior cases, cease and desist letters that have gone without satisfactory response. So there was also a focus on Midjourney's upcoming video creation service, which could create content using these same protected characters. So this will be a big fight that the AI companies have to get into, and definitely seems to be another facet. This is from the very beginning. I was talking about this, saying, look, if I ask a service to give me a picture of Darth Vader wearing a Spider-Man costume, it can do that. And maybe that's a transformative kind of a use of some sort. But if I just say, give me a picture of Darth Vader or Mickey Mouse or Spider-Man, it can output a pretty accurate depiction that is, for all intents and purposes, the same as or close enough, substantially similar for sure, to the original character.
So let's say it is transformative, your Darth Vader Spider-Man mashup. Who created that? Did a human create it? I don't think a human created it. So it's not, I would argue, not protectable by copyright. Thus, does that mean you can't sue for copyright infringement?
If somebody then copied the output from my prompt for that, probably not. I wouldn't have a claim. I'm not the owner of that copyright. But take it out of that, because I think that's parody and there's all kinds of other things that would sort of make that image maybe okay. But if it's just, hey, give me a picture of Darth Vader swinging a baseball bat or something like that. Well, the Darth Vader character belongs to Disney. And if the service, whichever AI it is, outputs that character and the audience recognizes it, sees that it's Darth Vader, it doesn't have a lot of, it is Darth Vader and it's substantially similar. The question is, who's responsible for that infringement? If the person who prompts the system is that person responsible for creating that unauthorized derivative work, if it's even considered a work? But the system outputting something that is so substantially similar, that's what Disney and Universal are now pointing at.
I think so. So we've got another case. Federal judge rules in favor of Anthropic in an AI copyright case. This is out of the Northern District of California.
Big breaking news just the other day.
Yeah. Bartz versus Anthropic. Authors filed a lawsuit against Anthropic last year, arguing that the company used pirated versions of their books without permission or compensation to train Claude, that version of AI, to respond to human prompts. Anthropic told the court that it made fair use of the books, and the U.S. copyright law, quote, not only allows but encourages, end quote, its AI training because it promotes human creativity. The company said its system copied the books to, quote, study plaintiffs' writing, extract uncopyrightable information from it, and use what it learned to create revolutionary technology, close quote. Copyright owners said that AI companies are unlawfully copying their work to generate competing content that threatens their livelihoods. Anthropic moved for summary judgment on the issue of fair use only, and on Monday, June 23rd, Judge Alsup agreed with Anthropic that the training was, quote, exceedingly transformative. The judge went on to say, like any reader aspiring to be a writer, Anthropic's LLM, large language model, trained upon works not to race ahead and replicate or supplant them, but to turn a hard corner and create something different. Okay, evaluating fair use. At least we still have 4 factors to look at. Plus transformative. Right. So, purpose. This was in favor of fair use as the books were used to teach the AI and differentiated it by comparing it with the recent Westlaw decision, in which case the Westlaw's content to create a competing product, the Westlaw content to creating competing product, while here it was used to generate something new. That was the Westlaw keynotes and key numbering we talked about earlier. There was no issue in destructive scanning to turn unpurchased books into scans. They actually bought the books they wanted. Interesting, which evidently tilts further toward fair use.
Well, actually, it was some of the books that they used. They had bought and broken up and scanned and then discarded the original print. Okay. But anyway, we'll get into that in a minute. Go ahead.
Okay. The nature of the books contain substantially creative elements, so that weighed against fair use. Substantiality. They copied the whole thing. So this factor, again, weighs against fair use. However, for training and the creation of a library, it was weighted for fair use. Okay. Economic impact. For training, it weighed in favor of fair use. Again, because of this whole learning aspect, and the court left open the idea of AI being trained to create knockoffs, indicating that would be treated differently. Destructive scanning was deemed neutral. And we keep using the term pirated copies. I guess they had unauthorized copies, weighs against fair use.
Yeah, the facts of the situation was that yes, they bought about 1 million books that they incorporated through this scanning process, but they also downloaded from various pirate sites about 7.5 million books.
Oh, well, there you go. That's okay.
So those are the pirate ones.
I missed that.
And the judge did distinguish between those two, saying that the pirated ones, the ones that were downloaded from these unauthorized sites, that was a different kind of use. And anyway, the opinion is very well written, well organized and structured opinion, and not terribly long. So worth a read for sure. And continue on with the summary.
Yeah, well, so in this case, which is this Bart's v. Anthropic, the group of plaintiff authors also brought into question the matter in which Anthropic attained and has stored the works. Again, this is what you're talking about. According to the lawsuit, they sought to create a central library of all the books in the world to keep forever. But millions of these works were downloaded, again, from pirate sites. So the judge granted Anthropic's training of these materials as a fair use, and everything else related to the central library and the nature of that is going to go forward in a trial.
Yeah. So as I was reading it, what was interesting was that this distinction between the pirated and the scanned, and the judge sort of hung a lot of weight on if you buy the book, sort of a first sale doctrine, and in fact actually referenced the Kurtzsang decision of the textbooks. The judge said, there's no duplication because they've destroyed the original. So now what they've done is changed format. And he actually cited the Betamax decision, saying it's sort of an equivalent of time and place shifting for how you're going to consume and making it more searchable. He did say, yeah, that's a sort of transformative kind of a use as well. But once you've decided not to, and the training of the AI LLM, also very transformative. But where he drew the line was saying when you decide, we're not going to put that book in as a training tool, but we're going to still keep it over here in the library.
In the depository.
Right. Then that became an inappropriate use, a possibly infringing use. So there's going to be a trial on that and a trial on the damages for that. But the training of the AI, the front end training, he's saying it's fair use. So I would expect that these authors, this is a case that was proposed as a class action. And the certification of the class is still pending. So it may, that will affect, of course, the scope of damages. If you've got all of the authors whose material is in the library, that's going to be different than just these 7 or 5 entities, whatever it is that are in the case now. So, there's a long way to go, and I would expect that these authors will probably appeal this decision on the fair use, because kind of have to take it all the way if you can.
Yeah, they're going to have to. They're going to have to appeal.
And there's an awful lot of other folks out there with cases pending. The interesting thing was that distinction between the Westlaw case, which we all sort of, raised our hands and eyebrows about, saying, what was it, Thomson Reuters versus,
Thomson.
I can't remember the defendant in that case, but where the judge said, no, it's not fair use. And this judge distinguished that, saying, yeah, but that wasn't outputting. I'm sorry, that system was designed to output the actual case text. And here.
And it was competing.
Yeah,
it was a competing service.
Yeah. And this system is specifically designed, apparently, according to some information in the opinion, to not output verbatim copy of the book, but instead to output similar information and style. So, and he says, look, when you read books, you learn the style, you learn how to write, you learn how to use the language. That's what training these LLMs is doing. I'm not sure I buy that completely, but anyway, that's sort of one of the arguments here.
Yeah.
So pretty big case. We'll be certainly following what happens in it as it moves through appeals and other things. But for now, at least we have an opinion saying, yeah, it's fair use.
Yeah. So. Well, the music industry is taking their stance, and 3 companies, Universal, Warner, and Sony, are in discussions with AI platforms, music platforms, Suno and Udio, seeking licensing fees as well as a modest equity stake. I don't know what modest equity stake relates to, or how much is modest. In June of last year, the music companies filed suit against the 2 startups in the U.S., alleging unauthorized use of copyrighted recordings to train their AI systems. So we've got recordings versus books. In court filings, the companies acknowledged using the material, but they made this claim of fair use protection as well. The licensing discussions came following similar arguments between OpenAI and the developer of ChatGPT and media organizations such as News Corp, the AP, and Vox Media. In addition to the lawsuits here in the U.S., Suno is also facing a copyright infringement case in Germany, filed in January of 2025 by GEMA, G-E-M-A, which is the country's collective rights management and licensing organizations for songs, for musical compositions. So they're getting hit on a couple of different fronts. We'll see what the German law and the EU, I know we've talked in the past about certain EU directives on AI, how that stands up, but will they be less likely to go forward on a settlement after this recent judge ruling in Anthropic?
Yeah.
I don't know.
Yeah. I mean, I think it may be a little too soon for that. We'll see what happens. But I think that if there are other rulings also saying, yeah, it's fair use, if they're following the logic of the Anthropic decision, then we're going to see the companies looking for licenses more motivated to deal for sure, rather than wait for lawsuit outcomes. And on the other hand, the AI companies probably less motivated to deal. Yeah.
And I'm wondering if the music industry has finally learned from Napster and Spotify.
If you can't beat them, join
them.
Napster,
MP3, Spotify. That we've, as much as it often stinks for the creator down the line, is it better than nothing? Something is better than nothing, even if it's not the greatest deal. I don't know.
And this is one of those areas, and I think Napster was sort of the beginning of this kind of thing too, where we're trying to close the barn doors after the horses have already fled. The AI is there. It's out there. And I don't think we're putting the genie back in the bottle, to combine more metaphors.
I did read an article saying the percentage of just how much, if you only rely on things like ChatGPT or Claude or these other methods for your research, you're not as creative. You've lost your ability of independent thinking. Yeah. I mean, it was really interesting. Now, I don't know if they used AI to create that study, but
no, I think I saw the same study.
Your processing skills, and I mean, I guess maybe the people who are learning how to really create these amazing prompts, they maybe are using a lot of their brain bandwidth, but
it's different bandwidth. It's not the creativity. It's more of the logic of understanding how the system works.
And maybe that's why I'm an attorney. I should be logical.
Is humanity going to evolve to have a bigger right brain than left brain, and our skulls will change shape and all that? Who knows? But
is that not yet the concern? That we're taking these things that are very creative. And maybe this was the whole conversation when MIDI came out in 1980, whatever it was. We've turned it all into ones and zeros.
Yeah. Well, again, the closing the barn doors after the horses are gone. But I think it's worth paying attention to. Certainly, as parents, I've discouraged my kids from relying heavily on AI. At the same time, I sometimes do rely on AI, not for legal work so much, but some of the content that I create and things like that. And if I have to sit down and write it myself, I'm already noticing it feels harder to organize my thoughts and get the words onto the page without the help of the tool. So that's motivated me to.
I think it should motivate us, even if we want to keep that side of the brain going, even if it's not necessarily related to work, that we need to be having expressive creative outlets.
If you don't work the muscle,
don't involve
it atrophies.
The computer. Yeah.
Well, another music case is a quickie. The Ed Sheeran Thinking Out Loud case back in, I don't know, what was the original opinion? Was about a year ago, a little more. Anyway, the Supreme Court has declined to hear the appeal. It was 2023 copyright case. The appeal brought against the Ed Sheeran Thinking Out Loud. This was a copyright infringement. Sheeran won in Manhattan federal court over the alleged copying of Marvin Gaye's Let's Get It On in his song Thinking Out Loud. That was filed by the company Structured Asset Sales that owns a share of the rights to the song Let's Get It On. And the allegations were that he'd copied the melody, harmony, and rhythm from the original. But the jury ruled in Sheeran's favor, and the Second Circuit found no reasonable jury would find that the two songs taken as a whole are substantially similar, and Supreme Court's declined to hear it. So a nail in the coffin lid on this case. But there's still another lawsuit against Sheeran based on the rights to the audio recording of Let's Get It On. So that case is currently pending and on hold, but we'll see. So,
yep.
Anyway, well, that's the wrap up for this episode of Entertainment Law Update. And very glad that everybody could be here with us. And thank you to the listeners for spending your time with us. And hey, if you have feedback for us, and we hope that you do, we'd love it if you would visit the website at entertainmentlawupdate.com and use the widget on there, the little red tab on the side of the screen, and leave us a recorded message or send us email, entertainmentlawupdate@gmail.com. You can find us on most social media sites in one permutation or another of Ent Law Update. And Tamara, how about folks finding you directly?
Yeah, they can find me online, createprotect.com, harperbates.com is the firm I'm a partner at now. Most social media at Tamera Bennett, TamerABennett.
And I'm Gordon Firemark in Los Angeles, where my website is firemark.com. gfiremark@firemark.com is the email. And on most social media sites, I am gfiremark. Finally, let's give a shout out to our team of volunteer contributors. Managing editor is John Janicek. We have Charles Thorne, Alexis Allen, Violet Zhang, Dawson Holder, and Lelwa Masedi all helping us out on this episode, and we appreciate their help immensely. And hey, if you are interested in joining the fun and being a part of this little family of contributors, I hope you'll reach out to us. Send us an email, entertainmentlawupdate@gmail.com. And with that, I'll push the sound button and we'll go to music. And that wraps up this episode of Entertainment Law Update. Thanks again for listening. And until next time, that's showbiz.